Good morning, this is your Kelso Report for Tuesday, August 28th, and I'm your host, Clark Kelso. We begin today with a case from the Ninth Circuit involving prior conduct evidence. The defendant in United States v. Bailey was convicted of 2 counts of securities fraud based largely on the testimony of one witness who had testified in return for hopes of a lesser sentence in his own case, and on the introduction of a different securities fraud complaint lodged against the defendant in 2002, 1 year before the allegedly illegal fraud in the main case. The defendant was convicted. On appeal, he argued that the prior civil complaint amounted to impermissible other act evidence barred by Federal Rule of Evidence 404. Now, as I'm sure you all recall, under Rule 404A, evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. However, Rule 404B does permit evidence of prior wrongs or acts to show proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. The government argued that the evidence was used to show proof of intent and knowledge. A majority of the Ninth Circuit agreed with the defendant and reversed the conviction. The majority held that a mere accusation of prior conduct is insufficient to support a finding that the prior act was committed, and therefore does not tend to prove that the defendant committed the act for which he was on trial. Instead, in order for evidence of prior accusation to be admissible, according to the majority, there must be sufficient independent evidence besides the accusation alone to support a finding that the prior conduct occurred. Since no such evidence was introduced in this case, the prior complaint should not have been admitted. Concluding that the error was not harmless given how weak the government's case was, the majority remanded for a new trial. Next, we have a rarity in state death penalty litigation, where the Supreme Court of California actually vacated a death sentence, this time on habeas review, in the case of In re Bacigalupo. The order came because of prosecutorial misconduct, a Brady error, failing to turn over to the defense material and favorable statements by an informant who told the prosecution that she had learned the killing in the case was a contract killing and the defendant had been ordered to do the killing by a Colombian drug lord who threatened the defendant's life and the life of his family. With these statements and other evidence that might have been developed therefrom, the defendant would have been able to present duress as a mitigating factor against imposition of the death penalty. That was enough for the California Supreme Court to vacate the death sentence. Next, the California Supreme Court, is that the right one? Reasonable doubt instruction. Nope. That's better. Next, the California Supreme Court had to reconcile 3 statutes involving the powers of the juvenile court in re Greg F. Welfare and Institutions Code Section 733C establishes a general rule that a ward cannot be committed to the Department of Corrections and Rehabilitation, in particular the CDCR's Division of Juvenile Facilities, unless the most recent offense alleged in any petition or admitted or found to be true by the court is one of the violent offenses listed in Section 707B. On the other hand, Section 782 provides that the juvenile court has the power to dismiss any wardship petition if the interest of justice and the welfare of the minor require such dismissal. Well, these 2 provisions came into apparent conflict when a ward on probation for a CDCR eligible offense committed a new offense that is not CDCR eligible. And then the prosecutor filed a new Section 602 wardship petition. Well, under the plain language of Section 733C, the court could not order a CDCR commitment. However, if the prosecutor had filed a petition to revoke probation under Section 777, instead of filing a new Section 602 petition, well, then the juvenile court could have revoked probation and sent the juvenile to CDCR. Recognizing that they had made a mistake in filing the 602 petition, the prosecutor then filed a motion to withdraw that petition after the juvenile had already admitted the allegations, and the prosecutor sought to revoke probation. The juvenile court solution was to invoke Section 782 to dismiss the 602 petition and then revoke the prior probation, resulting in the juvenile being sent to CDCR. The California Supreme Court agreed with this procedure, essentially letting Section 782's broad grant of discretion to the juvenile court trump the narrower and limiting provision found in Section 733C. Next, we have a case involving the failure to give a reasonable doubt instruction. Hard to see how a court could have made this mistake, but it did. It is such a fundamental precept of our criminal justice system that before a jury may convict a defendant of a criminal offense, it must find that the prosecution has proved all elements of the offense beyond a reasonable doubt, that you might have assumed that the failure to give a reasonable doubt instruction invariably requires reversal of a conviction. But according to a majority of the California Supreme Court in People v. Aranda, you would be wrong. It turns out that a harmless error analysis can apply even to the failure to give the reasonable doubt instruction, at least in certain cases. The problem in People v. Aranda was that the court gave a reasonable doubt instruction as to the murder charge in the case, but then it failed to link that instruction, or otherwise give a second reasonable doubt instruction, to the separate participation in a gang charge. According to a majority of the Supreme Court, when the trial court's omission of the standard reasonable doubt instruction constitutes federal constitutional error because the principle, although mentioned elsewhere in the instructions, was not specifically linked to the elements of one of the charged offenses, that omission and error is subject to harmless error review. In particular, in such a case, the failure to give the reasonable doubt instruction can constitute harmless error if it can be said beyond a reasonable doubt that the jury found the defendant's guilt beyond a reasonable doubt. Chapman error type analysis. I must confess that I'm probably more with Justice Liu's dissent here than with the majority, since I have a little trouble understanding how an appellate court can ever conclude what a jury might have thought it was doing when the reasonable doubt instruction was clearly connected only to one charge and was not linked to the other charge. How do we know whether the jury found guilt by a reasonable doubt on that charge? Aren't we really just speculating at that point, particularly given how fundamental the reasonable doubt instruction is to a finding of guilt in a criminal case? But that's Justice Liu in dissent. The majority thought harmless error analysis applied in this type of a mixed case. And that's it for today's Kelso Report. Have a great day in the law.